Speaker, I yield myself such time as I may consume.
Gentleman's recognized.
And I rise today to oppose H.R. 192, yet another attack on home rule in the District of Columbia. I wish we were here today talking about climate change, which is a dagger at the throat of humanity. We've seen record drought in the Midwest, record forest fires in the West, record flooding in the East, hurricanes of record velocity in the distinguished gentleman from Louisiana's beloved Gulf Coast. There were mosquitoes in the North Pole last summer. The sea levels are rising everywhere. But we're not here to talk about that emergency. I do have a book for my friend, Mr. Higgins, called Bayou Farewell, written by one of my constituents about what's been taking place on the Louisiana coast that I'm going to offer to you today. But we're not talking about climate change. We're not talking about gun violence, despite the fact that America now has rates of gun violence and gun-related mortality 20 times higher than the nations of the European Union. Gun violence is now the leading cause of death among children and young people under 18 in America. It's out of control. But we're not talking about that. We are exercising our constitutional authority, as my distinguished colleague from Louisiana says, to oversee the District of Columbia. And here today, what's caught our eye is that they have legislation which passed, which has become law in the District of Columbia, which allows permanent residents and other non-citizens to register to vote. So they have nearly 500,000 registered voters in the District of Columbia. 512 of them are non-citizens. Around a little bit more than 0.1% of registered voters are non-citizens. Their primary election in 2024 has already begun. The D.C. voters got their ballots or began receiving ballots in the mail on April 29th, and the district has already begun accepting ballots. The D.C. Council had transmitted the Local Resident Voting Rights Amendment Act of 2022 to Congress for the required review period on January 10th, 2023. The House passed a disapproval resolution, as my friend mentioned, on February 9th, 2023. The Senate did not pass the disapproval resolution there. The act became law in March of 2023. So what we're talking about now is passing legislation to overturn a practice that is literally taking place as we speak within the District of Columbia. Now, the critical point everybody needs to understand is that the District of Columbia has no voting representation in the House of Representatives, nor does the District of Columbia have any voting representation in the United States Senate. And their legislation doesn't apply even to their non-voting delegate in the House, nor does it apply, of course, to presidential elections. So what we're talking about is, should these 500 or so people in the District of Columbia be allowed to vote for Advisory Neighborhood Commission, school board, and members of the D.C. Council and mayoral elections. Now, the practice of non-citizen voting, my friend may be interested to learn, is one that actually was adopted in the vast majority of American states at different points in American history, including, I checked, in Louisiana, where it existed for around a decade. It started, as far as I could tell, with this basic premise that when the country began, there was a race qualification, there was a gender qualification, there were property, wealth, and religion qualifications in different places. But the basic logic of it was that if you are a white male property owner, it doesn't make any difference what your citizenship status is. And that lasted really up until the Civil War. The practice of alien suffrage at the local level was one that became hotly contested before the Civil War. The southern states opposed it because they said that the immigrants who were coming in, who were being given the right to vote, were anti-slavery, they were abolitionist. The northern states, and specifically the Republican Party and Abraham Lincoln, defended the practice of non-citizen voting. This was a major bone of contention geographically, sectionally in the country with legislation like the Kansas-Nebraska Act and other statehood admissions struggles. Well, when the South seceded from the Union and wrote their own Constitution, the very first article of the Confederate Constitution banned the practice, which we're discussing in a very modified form today. They banned anybody from voting in the Confederacy who was not a citizen of the Confederacy. When the Union won the war and the secession was put down, alien suffrage spread across the country. Again, the Republican Party championed it, and they championed it in the form of something called declarant alien suffrage, which is for people who were permanent residents of the country who were on the pathway to citizenship. They were given the right to vote, especially in a lot of the western states, as those states tried to attract population westward. The practice appears to have been diminished and eliminated in a lot of places around the turn of the 20th century and before World War I. And it survives today in the form that the District of Columbia has fastened onto it for local voting, on the theory that you want people at the local level to be involved in their kids' schools and you want people to be engaged in local government. We ban non-citizen voting at the federal level, which means we also ban it at the state level because they're linked constitutionally in Article 1. So what we're talking about is non-citizen voting chosen by a local government at the local level simply for municipal elections. And the basic logic of it there, as I understand it, from just trying to read up on what the people in D.C. did, was that they saw that while non-citizens from Canada or Mexico, for example, shouldn't be able to vote in national elections because the interests of the United States and Canada and Mexico may diverge, at the local level, everybody presumably has the same basic interests in efficient garbage collection, excellent public schools, and so on. So that's why they've done it. It affects a relative handful of people, and I'm not quite certain why we would be engaging in legislative action to overturn it, except for the purposes of sending, some kind of message about it. The gentleman also mentioned diplomatic personnel and undocumented people. Well, as for the diplomatic personnel, a foreign passport may not be used to register to vote in the District of Columbia. The person has to have a residential address in the District of Columbia, and it cannot be an embassy or another diplomatic site because you can't register at your place of work. And I don't know whether the gentleman has actually any evidence of this happening, and I think if there were, that would be something we'd be interested in. Same thing with undocumented people. It would, of course, be crazy for an undocumented person to attach their name to a public and transparent document like a voter registration document. I don't know if they have any evidence that this has happened, but we were not able to find any evidence that there were any undocumented people doing so. In other words, the district's use of this practice for local elections and local government functions appears to be in accord with the way it's always been used, which is for permanent residents who are part of the community who are on the pathway to citizenship. And with that, I will reserve.